Welcome to Case Study Series in Business Ethics Case Study by Skilled MBA. In June 2024, ExxonMobil initiated a lawsuit against Arjuna Capital and Follow This, two small activist investors. These shareholders had requested greater transparency on Exxon's carbon emissions reduction strategy. Instead of using regulatory channels, Exxon chose federal litigation to block the proposal, marking an unprecedented legal escalation in corporate governance. In June 2024, ExxonMobil initiated a lawsuit against activist investors Arjuna Capital and Follow This. The investors sought increased transparency on Exxon's carbon emissions reduction strategy. Rather than addressing the proposal through regulatory means, Exxon opted for federal litigation to prevent the proposal from advancing. The core ethical questions arise. When does a shareholder proposal overstep into management's domain? Can environmental, social, and governance activism be disentangled from financial performance? Should corporations wield litigation to suppress shareholder proposals they oppose? These questions challenge the balance between corporate power and shareholder rights, highlighting the tension between financial priorities and ethical responsibilities. Exxon argues that the proposal distracts from its core business, undermining its fiduciary duty to maximize shareholder value. They assert the right to exclude proposals interfering with ordinary business, emphasizing a financial focus where management prioritizes profitability over activism. A federal lawsuit aims to set a precedent against similar future proposals. Activists argue that climate issues significantly affect long-term company performance and value. Shareholders, as owners, have the right to voice strategic concerns. They emphasize the need for transparency, asserting that greater disclosure leads to more informed investment decisions, benefiting all stakeholders. California Public Employees Retirement System criticized Exxon's aggressive legal tactics, highlighting the importance of shareholder rights. Norges Bank supported activists' rights to file proposals, emphasizing the need for transparency. Major asset managers expressed concerns about the implications for shareholder democracy, underscoring the broader impact on corporate governance and investor relations. Arjuna Capital withdrew its proposal, making that aspect of Exxon's lawsuit moot. Follow This, a Dutch organization, was outside United States court jurisdiction. Consequently, the case was dismissed, leaving no definitive precedent on shareholder proposal rights. Shareholder democracy hinges on the proxy process, where annual meetings enable voting on proposals. This system depends on management's acceptance of valid proposals. Exxon's lawsuit disrupts this norm, seeking court intervention. Climate-related proposals, averaging 30% support at oil companies, see over 200 filed annually with major firms, highlighting the growing focus on environmental issues. Shareholder activism has evolved significantly. In the 1990s, 2000s, it centered on governance issues like executive pay. From 2010, 2020, climate proposals gained traction, with most companies engaging rather than resisting. However, since 2020, an environmental, social, and governance backlash has emerged, with some firms, like Exxon, taking aggressive stances against proposals, potentially altering corporate shareholder dynamics. The fiduciary duty debate contrasts traditional views focused on maximizing short-term profits with evolving perspectives that consider environmental and social impacts for long-term value. The stakeholder model seeks to balance interests of shareholders, employees, communities, and the environment. Courts are increasingly recognizing climate risk as a relevant factor in fiduciary duty considerations. The Securities and Exchange Commission requires shareholders to own a significant stake for over a year to submit proposals, which must not interfere with ordinary business. Companies can request no action letters from the Securities and Exchange Commission. Interpretations of ordinary business are evolving, and proposed climate disclosure rules may mandate emissions reporting, reflecting a changing regulatory landscape. The European Union leads with robust ESG disclosure regulations and shareholder engagement rights. In contrast, the United States faces a more contentious environment due to political polarization on ESG issues. India is witnessing a burgeoning ESG movement driven by business responsibility and sustainability reporting mandates, reflecting a global shift towards sustainable corporate practices. Securities and Exchange Board of India requires environmental, social, and governance reporting for India's top 1,000 companies, reflecting rising shareholder activism and governance focus. Climate issues are crucial, especially in the energy sector. Indian firms must anticipate heightened scrutiny on climate strategies from global investors. The Exxon case underscores the importance of effectively managing shareholder proposals to avoid pitfalls. Exxon's lawsuit sets a precedent in corporate shareholder dynamics, highlighting the tension between management authority and shareholder rights. Environmental, social, and governance (ESG) concerns are now seen as financial issues, not just ethical. Engaging in dialogue rather than confrontation with stakeholders often yields more productive outcomes. Thank You and Exxon's lawsuit underscores the evolving landscape of corporate governance, where environmental, social, and governance (ESG) factors are increasingly pivotal. This case exemplifies the shift from ethical to financial imperatives in ESG considerations, highlighting the need for proactive engagement over adversarial approaches in addressing stakeholder concerns.